My name is Amanda Collins and I represent the appellate Carrie Gonzalez Lindbergh, and I would like to reserve 3 minutes for. Thank you. Do you please support? This case really turns on some pretty serious family discord. The finding of fees in this case against the appellant for petitions that she filed for guardianship of her mother is errors. There was never an evidentiary hearing on those issues. The underlying issues that are the basis for those petitions is that there exists a power of attorney and a trust agreement for the alleged incapacitated person. And the current power of attorney and trustees are exercising undue influence over the alleged incapacitated person and draining assets from her estate. And so basically there's 3 petitions which were initiated on June 24th.
Let me ask you a preliminary question, because much of what you are challenging in the brief relates to the findings contained in the November 2021 order, which has the language of bad faith. And in your brief, the argument is made that the November 2021 order was non-final. What is the basis for that contention? Which I assume means you didn't have to appeal it, is why that's in there. So what's the basis for that contention?
Yes, Your Honor, that was the argument of previous counsel. So even if the order.
Well, it's okay, you're arguing. So
Yes.
tell me why it's a non-final order.
So in the event that it is considered a final order, we say that it's still appealable because it relies and basically brings back like the order that was the basis for the final.
What's your authority for that proposition?
That is. So there's 2 cases, Your Honor, Sanders v. Chaplin. So normally an order determining if attorney's fees are reviewed for abuse of discretion. And there that's the same here, the statute is the basis.
So my question is, you've contended, or your clients contended in the brief, that the November 2021 order is non-final. So are you agreeing it's final, or are you still maintaining it's non-final? And if you're maintaining it's non-final, what is your authority for that?
No, Your Honor, we're willing to concede that it's a final order.
Okay, so it's a final order that contains a finding of bad faith in support of dismissal of the 3 petitions, correct?
Correct.
So how did we get to again review that finding, which was the basis for a final order of dismissal?
Because in this case, the second order relies on the finding of the first order. So the second order, you can't exercise or execute the order without looking back at the initial order that was the finding of bad faith.
Isn't that true of every post-decretal order that comes down after any kind of final order?
Well, yes, Your Honor.
So would every post-decretal order revive for appellate review the final judgment that preceded it?
Not necessarily, Your Honor.
So what would be the dividing line?
So in this case, the attorney's fees are claimed under a statute, which is a tool for sanctions against a party. And in Sanders v. Chaplin, it's almost the same exact facts. It's 334 723. So in that case, the argument was that the standard review should be de novo or review abuse of discretion, because an award of attorney's fees that's the standard of review. However, as when the statute is at issue, which in this case the statute that they're claiming the fees are awarded under is 744-331 Florida statutes. It's a tool for sanctions against a party who files a petition in bad faith, and the amount of attorney's fees is awarded is in the discretion of the court. But here, the discretion of the court, we're not arguing the amount of attorney's fees, we're arguing that the bad faith issue was revived by this order and the finding of attorney's fees.
I think just to echo Judge Silverman's question, I understand the argument. I'm just having a hard time filling in that gap, the reviving, the resuscitation of the order. How, well, under what authority are you hanging your hat on?
We don't believe that there's competent and substantial evidence to support the attorneys.
Well, that's your substantive argument, but in terms of whether we can even review that, it's a jurisdictional threshold that we have to have satisfied, or we can't even get to that substantive argument. Are you asking us to maybe forge a new trail and hold as a matter of first impression that this is a situation that warrants resuscitating the prior order?
Yes, Your Honor, I believe that in this case it is, because the whole finding of fees it relies solely on that finding of bad faith, which originally didn't even contain detailed findings of facts.
Hmm.
And it actually contains some errors in there as well, which are just holding contained errors, so.
which suggests that dismissal may have been improper to the extent it was relying on bad faith. But that's an order that needed to be appealed, and in fact was appealed and then voluntarily dismissed.
Yes, Your Honor.
So how do you get to now argue that there was an insufficient evidentiary basis when that had to be appealed after the November order?
Because our whole argument is that this order, the whole basis of the fees is that finding of bad faith, and the judge didn't give findings of fact or bad faith in this order. He relied and used the verbiage of his previous order.
But you said the Sanders case, what was the site again?
That is 334 Southern 3rd 723.
Southern 723,
Yes, Your Honor.
and was that 334 Southern 723?
Southern 3rd.
Southern 3rd. Okay. Was that cited in the brief? And honestly, I'm still having trouble finding it. 334 Southern 3rd 723. Oh, here we go. Sanders versus Chapman.
Your Honor, it was not cited in the brief.
And did you provide notice to the other side that that case, which came out March of this year, was supplemental authority?
No, Your Honor.
Did you provide any supplemental authority notice to the other side of any case that you're arguing today that was not in the brief?
No, Your Honor, it was just this case.
Okay. I'm looking at the case right now. Point me to where in the case it talks about revival of a prior.
Your Honor, I'm looking at page. Starting at 961, the quote generally when the record of appeal.
I'm sorry, you said page 961.
I believe,
That's a problem because the
Yeah.
case starts at page 723.
oh, I'm sorry, I'm looking at the wrong piece. I believe it's starting on page 725. While ordinarily orders determining attorney's fees.
Which head note is it under? So I can click on that. That'll take me right to it.
Number 2 analysis.
While ordinarily orders determining attorney's fees are reviewed for abuse of discretion, award involving interpretation of statute is de novo. That issue of 2 statutory provisions. There's entitlement language payable by the estate. Okay, so I'm still not finding anything where it talks about revival of a prior order for review.
Your Honor, I think the argument of my client is that the prior determination of bad faith was not outlined in the fee order.
And I understand that. So tell me how this case supports what you're arguing, which is that you now have a chance to attack the November 2021 order in this appeal. And you told me a moment ago that this case stands for the proposition of reviving the earlier order for review. So help me find that language.
I don't think that's actually what I meant to say, Your Honor. So we're arguing that the second order that orders my client to pay the fees of the entire proceeding is not sufficient on its own. You can't read it without reading the first order.
I understand your argument. Have the opposing counsel, do you have the copy of the Sanders case?
No, Your Honor.
Would you please give them your copy of the case so they can take a look at that?
Yes, Your Honor.
You can proceed.
So, Your Honor, in this case, the election incapacitated person is the mother of the appellant and the appellee, and the attorney, in fact, is her granddaughter. And so the appellee and the granddaughter have trustees under the trust, and the granddaughter is also the attorney, in fact. And the whole purpose for filing this case is that the three petitions that are being attacked here, they outlined specifically the bad acts of the appellee and the attorney, in fact. So here, the court cited in the order, there's no alternatives to the appointment of guardians such as trust agreements, powers of attorney, and it goes on because of the facts listed in paragraph 4 above. And if you go back to the judge's order determining that the only dismissal that was in bad faith according to the order was the petition for appointment of a guardian. So in that order, the judge found that it was filed in bad faith because it fails to properly state a cause of action due to false and incomplete statements. However, the judge's quote eliminates the second half of that sentence. The judge relies their decision basically as if there's no alternatives known to the petitioner. However, the second half of that sentence says, because of the facts as spelled out in the petition for emergency temporary guardianship. And
But
that,
let me ask one question as to the allegations that the judge seemed to be concerned about. It appears the court felt that there was a conclusory allegation, and I think it's in each of the documents, but in the petition for appointment of emergency temporary guardian, it says that the physical or mental health or safety of the alleged incapacitated person will be seriously injured, impaired, or the property in danger of being wasted, and so forth. Because the attorney, in fact, is draining the ward's assets by transferring assets to herself and her mother. And there's some more conclusory language. It strikes me that the court may have been concerned there was no specific allegations of fact fleshing out what that misconduct was. My question is, if we can go back and review the November order, was there any request for leave to amend the petition to include more detail?
no, Your Honor, there wasn't. The three petitions were filed on the same date, and they basically bounced off of each other. So they used the facts from each of the petitions.
So
So
did any of the three contain more detail as to a particular asset that was improperly transferred?
absolutely, Your
That
Honor.
was one of the properties, I think.
Yes, sir. So in document 3 of the record is the petition for emergency temporary guardianship that lists out in paragraph 4A through 4G, the specific acts that are alleged.
Which is the one property.
Well, there's after,
I think B talks about Naval sold the property, the AIP property, and then there was some language about transfer of the ownership of an entity.
yes, Your Honor,
Okay.
which is several hundreds of thousands of dollars worth of property were flowing from the trustees to themselves without compensation to the alleged incapacitated person. And my client, the appellant, only came aware of this.
So you're not only asking us to review the bad faith finding, you're asking us to go back and conclude that the bad faith finding was incorrect because there were sufficient allegations in the petitions when read together,
Correct, Your Honor.
which is a challenge to that November order, right?
Correct.
Okay. You've got, I know you have reserved 3 minutes, you have 4 left.
Thank you, Your Honor. There's several other things that occurred. So within basically the promulgation of this was there was an eviction filed against the appellee by the corporation, which is owned by the election capacity person and the appellant. And within days of that being filed, now there comes into existence a share transfer agreement, transferring the shares of the corporation from the election and capacity person to the appellee, which is a multi-million-dollar property. And that through the litigation of those cases, we've become aware of multiple properties that have been transferred from the election capacity person to the appellee, who's the trustee of the trust and the attorney in fact, who's also the trustee of the trust, they're co-trustees. Your Honor, may I reserve the remainder?
I'm sorry.
May I reserve the remainder of my time?
Yeah, you've got just over 3 minutes. Thank you. Let me ask you a preliminary question. Are you dividing time or are you arguing the whole thing?
I'm arguing the entire.
Or you may proceed.
May it please the court, my name is Gianna Weber on behalf of the appellee Maple Gonzalez, and here with me today is Sue Wade. Your Honors, the issues presented by the appellant are straightforward when everything boils down. As you've noted, it appears that you've noted that there was a final order, the order dismissing the initial petition that included the bad faith finding. And the Florida Rules of Appellate Procedure do specify that an order refusing to appoint a personal representative or guardian or determining a petition for motion to determine incapacity. Those are types of final orders that are specified within Florida Rules of Appellate Procedure 9.170. So what we're left here is an abuse of discretion standard, and we would not submit to the court that there is any de novo review that would be appropriate here. And just in a cursory review of the Sanders v. Chapman case, it does not appear to suggest that that the attorney fee award of this case involved interpretation of a statute. There was the mention of the bad faith finding from the prior order, but the court's order did not have any discussion at length about the statute and interpreting what it meant as a matter of law. So we would suggest that the Sanders v. Chapman case is not on point and does not support changing the standard of review here.
So that in reviewing the record, I am concerned about some of the events that took place in relation to the November hearing, including the fact that it seemingly was non-evidentiary, and that was pointed out to the trial court. But I take it your position is that may have been error, but we don't get to review that at this point in time because that order was not timely appealed.
Yes, the order was timely appealed, but it
Appealed and then
was
dismissed.
voluntarily dismissed. So yes, I would agree with that. However, I would not agree, I would not concede that there was order in not having that motion to dismiss hearing be an evidentiary hearing. I'm not.
Isn't an evidentiary hearing required to make a finding of bad faith?
There is a requirement of notice of an and an opportunity to be heard, and the opportunity to be heard does require an opportunity to present witnesses and evidence. And it's our position that the appellant did have the opportunity to present witnesses and evidence, but did not request, did not actually, seek
He
to.
did, counsel did object that it wasn't an evidentiary hearing, didn't he?
I don't recall that hearing was, that objection was made at the motion to dismiss hearing.
You might want to read the transcript
Okay.
again.
All right, I'll take another look at that, Your Honor, thank you. But our other argument is that for the fee hearing, that was clearly an evidentiary hearing. And there was a witness presented, that was the expert witness.
There was no dispute. I think ultimately there was no dispute as to the reasonableness of hours and hourly rate and so forth. The question came down to, was it supported by bad faith?
So our position is that the appellant could have presented witnesses on the bad faith issue at the fee hearing, but chose not to do so. And there isn't anything in the record where she attempted to present an expert or another witness on the bad faith issue at that hearing. So we would say that that argument is not properly preserved, that she did have sufficient notice and opportunity to be heard and to present witnesses. The fee order on its face doesn't contain any errors. It does include findings regarding reasonableness of hours and the hourly rate, and it mentions, of course, the bad faith finding from the prior order. So it doesn't incorporate by reference that prior order. And in that prior order, it did note that the appellant failed to meet the notice requirements, and it failed to properly state a claim. Now, the notice issue is important because when petitions were filed, no notice was given to the appellee, and the parties were in other litigation. They are sisters, so clearly the appellant had the contact information for the appellee, could have easily provided notice to her, but did not do so. And there is no excuse for that. Also, given the fact that there was no substantial harm that could have come to NG, and that was later supported by the order of Judge Corvo, who vacated the emergency order from the emergency guardian. So we have no error on the face of the fee order, and we have no transcript from the fee hearing. The trial court also made its order based on the totality of the circumstances, and it's impossible for the court to evaluate the totality of the circumstances, given that we don't have the transcript. Although in some cases, a fee order can be appealed with the time transcript, that's when the error appears on its face, and that is not the case here. Ms. Lindbergh has also made the argument that she should not be penalized for the alleged inadequacies of her former counsel. However, we would submit that those the issues that are found in the petitions should be imputed to Ms. Lindbergh because they were sworn petitions, and she is a professional person, well educated, and there's no argument that she was not able to read or understand petitions. The trial court's order is supported by substantial competent evidence, and the order dismissing the initial petitions is not an appealable order. The bad faith finding stands. Do your honors have any questions on those points? Additional points I wanted to raise is that I'm here on behalf of the appellee, but we do have jointers that were filed by the other parties. We have the counsel for Annie Gonzalez, who had the power of attorney, and we have a jointer from Mr. Sean, who represented NG, and also a jointer from Ms. Giordano, who represented the emergency temporary guardian. The amount of fees that were awarded in the fee order are not substantial, not outlandish by any means. We have $22,962.50.
That might be a matter of perspective.
For counsel for,
You asked for attorney's fees on appeal
yes,
on two bases, one of which is as a sanction. And I take it the argument that you're making on that is that because the November 2021 order is not appealable, that makes this a frivolous appeal.
yes, we are making that argument. There were just a number of, misstatements in the appeal, beginning with the standard review, as we noted, that it should be abuse of discretion and not de novo as they've asserted. I believe in the standard review, they reference an order on a motion to dismiss, and that's not what we're here on today. Also, going back to the petitions, they did include false statements, stating that there weren't any alternatives. And the order. We submit that you appellant knew or should have known that she cannot challenge without a finding in the order. She knew or should have known that she had an opportunity to be heard and present testimony on the issue of bad faith at a minimum at the hearing, and she chose not to do so. And it is our position that the appellant has wasted the court's time and the resources of the parties, as well as potentially NT if Ms. Lundberg were to prevail in this. And for all of those reasons, the appeal is frivolous, we would submit. Also, it is concerning to us that the Sanders case was not provided to counsel. If that is something that the court feels is necessary to have further reading on, we would request an opportunity to address that case in further review.
Very good. Thank you, Ms. Whitman.
Thank you.
Your Honor,
Ms. Cummings, I'll just point out, we often get notices of supplemental authority with authority that's decades old, which is not exactly what a notice of supplemental authority is. Your case from earlier this year may have been issued after briefing, but you should have provided that with a notice of supplemental authority. So both of you would have had an opportunity to argue it, and we would have had an opportunity to read it ahead of time.
yes, Your Honor, understood. It's our position that this is not a frivolous appeal. Not granting the appeal would be a miscarriage of justice in this case. Touching on some of the issues that were brought up by opposing counsel. So emergency temporary guardianships are governed by Florida statute 744.3031. There's no notice requirements in there. And the transcripts that have been provided for this court, prior counsel advised the court what happened. He filed emergency temporary guardianship, and less than 24 hours later.
So now you're asking us to review everything relating to the November 2021 order.
No, Your Honor, I'm just rebutting some of the assertions from opposing
I
counsel.
think we have a pretty good handle on what was in the November order. So I don't think you need to spend a whole lot of time on it. I mean, it ultimately comes down to, I think, at least in large measure, whether or not we get to reconsider the finding of bad faith.
Yes, Your Honor, and we did request a rehearing on that of the hearing in which there was the finding of bad faith, and it was denied by the judge. And then if we
And
look
then
at,
the appeal was initiated
yes, Your Honor.
and then it was dropped.
Yes, sir. The order specifically state granting the fees says, based upon the prior determination of a bad faith and consideration of the totality of the circumstances, the court determines the petitioner in this proceeding should be responsible for certain fees and costs. The finding is memorialized. The finding of bad faith is memorialized by the transcript. So if the order awarding fees is going to be based on that finding of bad faith, it's our argument that the basis underlying that finding should be part of the judge's findings in this current order awarding fees. So if the judge is gonna rely on a prior determination of bad faith, I believe that revives the order in finding that that bad faith determination was memorialized in the transcript, which this board has, and by the prior order, of it finding bad faith. I've no.
Very good. Thank you both very much. The next case on the docket is Chris Noco, Sheriff of Pasco County versus Easter.